And then I will put this on present now. I'm going to present the window. There we go. Okay, can you guys see both me and the presentation?
Yes.
I see.
Not if I have you pinned, I can't, because all I can see is still you. So let me unpin you. Yeah, now I can see the presentation.
Present now. I'm going to present a window. Where, yeah, I can see the presentation. Present now. I'm going to present a window. 2% window.
All right, so we're not going to, just for the record, we're just recording this just to test this out. This is not going to go anywhere, okay?
I know. I'm just enjoying reading the captioning of what it says.
I know, that was kind of pretty cool. All right. So, ladies and gentlemen, we're going to begin our class on bifurcating title for real estate transactions. All right, so bifurcating title for real estate transactions, how to save your buyer money on closing costs, right? So in this crash course, we're going to talk about 4 things and give you some time for questions at the end. The first question is, what's the law on bifurcated title? Okay, so we're going to talk a little briefly on what the law is in Illinois. Then we're going to talk about what is bifurcating title, what does that mean? And then why should I bifurcate title? And then how to actually do it. And then we'll give you some time for questions at the end. Okay? So in Illinois, per 215 ILCS 155/18.1, which is part of the Real Estate Title Act, buyers of residential property as consumers, and this is only for buyers of residential property, so commercial property doesn't count, they have a right to pick their own title company. And the idea for that was to save the consumer money and increase competition among the title companies. It also was to help prevent fraud. So a lot of times what would happen is the buyers, the attorneys and the agents and the real estate agents and the brokers and the lenders would all collaborate to force people into certain title companies and charge them more money, and they'd be able to gouge it, and then they wouldn't tell how they're making money, which opens up the issue on the third piece, which is it prevents parties from forcing people to pay for services from specific vendors against their will. So this also ties in, which we're not going to talk about a lot here, but in the Real Estate Closing Disclosure Act requires the attorneys and the parties to all disclose their affiliations. So if the brokerage, the real estate brokerage that's selling your house owns a title company, they have to disclose that they're making fees from that as well as the same thing with a lender. So if a lender is doing a refinance and forces you to use their title company, they have to disclose and tell you that you sign that they disclosed it to you, what their fees are they made from your title services. So here's the Title Act, and really it's a lot here, so I'm not going to read it out, but the issue is right in the middle. It says no lender or producer of title business, as the term is defined, shall make as a condition of the loan require to use a particular attorney, lender, or any other party force you to use a specific title company, okay? Or pay the title insurance, especially if you're paying it forward at your own expense. I mean, if everybody's going to pay your title costs, then it doesn't matter. But if you're paying as a consumer anything for title, you have a right to choose your own company. So what is bifurcating title? Bifurcating title is when the buyer on a real estate transaction picks their own title company. So what happens is the buyer breaks the title closing or the closing of the real estate closing into two deals happening at exactly the same time. The seller provides their own title company and the buyer has their own title company.
Wait.
Go ahead.
So there's two. So if the buyer picks their own title company, the seller has their own. They don't use the same?
No, exactly. So the buyer picks their title company and the seller gets their own title company. Hence, bifurcating, you're splitting the title in half. Okay.
Does that split costs in half too between them?
It does. So I guess what I probably had, so maybe somebody can send me a quick HUD or a sample blank HUD that I can actually show on this presentation if that would be helpful for me. But here's why we should bifurcate title. And we're going to talk about how it happens and what are the pieces that come up as we go through. But the question is, why should we do it? First of all, the buyer saves money. So on average, the buyer could save between $500 to $1,500 on their side of the closing fees. Okay. Now, the other reason is the buyer's attorney makes more money, and that doesn't cost the buyer anything. So I'll explain why that is helpful to the transaction. So first of all, if it's done right, the consumer will reduce from $500 to $1,000 in their closing costs. You're reducing the escrow fee, the lender's title policy, and the endorsements. So let me talk about that for a minute. So when you're buying a house or selling a house, there is a title company that handles the escrow, which means they take all the money from the lender, all the money from the parties, they take all the information, all the documents from everybody, and they hold everything. And once they get all the documents, the deed, the affidavit of title, they get the lender's mortgage, the lender's note, the commission statements, the water certificates, all the things needed for a closing. So they get all this and they'll hold it as an escrow. And then they'll pay it. So then they'll take the money from the buyer, give it to the seller, and pay everybody off. And then they'll take the deed from the seller, well, the seller's deed, affidavit of title that says who owns it, and gives that to the buyer. So now the buyer has title, and then they send the mortgage documents to the lender. So the lender gets their mortgage documents and their note documents. The seller gets the money, and the buyer gets the house. That's really what the escrow agent does. They handle all of the pieces and pay and give everybody their stuff that they're supposed to get. So they only distribute and disperse and give everything away when everybody signs the settlement statement or the HUD. All right. So now here's why the escrow fee is reduced. So normally the title company will charge a fee for doing all this. And in a transaction where it's an all cash deal, the fee is split in half. Buyer pays half and the seller pays half because there's no lender involved. There's no extra work that needs to be done to handle the buyer's mortgage. But when the buyer comes with a loan and is borrowing money to buy the house, all of that work becomes really heavy on the buyer side. So then what happens is the buyer pays the entire escrow fee, which could be anywhere from $1,500 to up to $2,000, depending on the title company. So when the buyer bifurcates, the buyer's title company takes on all that expense. So then what normally would be a fee of $1,800 or so, for example, from the seller's title company, if done right, the buyer's title company will say, well, thank you so much for giving me this deal. Instead of paying $1,800, we'll only charge you $1,000. Did everybody get that?
Yeah.
So now the buyer only saved $800 right off the bat just on the escrow fee to manage the deal. All right. Now, the other costs that come in is the lender for the borrower, for the buyer, says, hey, I want to make sure that I have an insurance policy. So the buyer actually pays the insurance policy for the lender to make sure the lender is first in line at closing. So in case they have to foreclose or take anything or take the property because the buyer hasn't paid or whatever normal happens in that course of action, they make sure that there's no other mortgages that are actually ahead of them. A big, huge problem that existed in the old 2005, 2006, 2008 crisis. A lot of fraud in that case. But in this case, the lender's getting an insurance policy guaranteeing that they're first in line and that there's no problems with the title. So normally this could be between $500 and $800 depending on the size of the loan. So in this case, again, the buyer's attorney and the buyer's title company says, hey, because you're coming to us, we're going to lower the lender's policy. So they may cut that in half. So now instead of paying $500 or $700 for the title policy, the lender's policy, they're only paying $200. Everybody get that piece. So now how much have we saved? We saved $800 from the escrow. We've saved $250 or so from the lender's policy. That's $1,050. Now the endorsements. Now endorsements are extra insurance provisions that the lender may want. So if there's a condo association, they get an endorsement for that. If there is a PIN or a survey, they get an endorsement for that. So there's different things that exist that they get endorsements for. But that endorsement can be between $185 up to $200 or more per endorsement. Well, based on that, the buyer's attorney, who was the title agent, and the buyer's title company says, we're going to reduce your endorsement fee from $185 down to $100. On average, there's about 3 endorsements per transaction. Okay. So that's what, almost $300 in savings, plus the $1,050 from the reduced escrow and the reduced lender's policy. So in total, a buyer could save about $1,300 or so from bifurcating title. Now, what does that mean? Is it just saving money? No. What happens is now, because they saved $1,300 from the closing, they get to bring less money to the closing because they're not paying their closing fees. They also get to pay less on their loan over time because they're not paying depending on how much money they had to put down and what their requirements were. They can also save money over the life of the loan because those costs are no longer amortized into their loan. Any questions? Did everybody fall asleep?
No.
Okay, just making sure. All right. So now, how does the attorney make more? So, and the attorney, just to give some background, the attorney makes between $400 to maybe up to $700 or $1,000 per closing, right? On a residential transaction, it's usually between $400 to $600, $650 maybe, right? So the amount of time the attorney has to put in between the attorney review, the documentation, reviewing documents, going back and forth with the lenders, going back and forth with the seller's attorney, you could put anywhere almost up to 30 hours of work on a file, and it still may not close, and you only made $400 on the file, right? So most attorneys do buy-side closings because they want the sell side down the road in the future, or they're appeasing their brokers so that way they get more deals from their brokers and they get more referrals. So they'll do these types of closings. However, in the bifurcation, because it's 2 title companies and because the buyer's attorney is bringing the buyer's title company in, the buyer's attorney is what we call the title agent. So they're the ones that are insuring and issuing the title policy along with the new title company or the buyer's title company. So then that the $100 that you paid for the endorsements, the $200 that you paid for the lender's policy, you would have paid, remember, $1,300 more to the seller's attorney, because normally the seller's attorney collects all that. But instead, you get to save $1,300, and your attorney gets to make twice the amount of money they would have normally made, which is huge because now the attorney has, I'm not saying they don't have an incentive to do the closing, but it's always good to feed your horse, right? So if we're horses, you want us to run and work, feed your workhorse. It's a good way to help feed your attorney and get them paid without having to cost you any more money. Now, I do want to indicate, because there's 2 title companies, the seller's attorney is still going to issue a seller's policy, an owner's policy. For the owner who sold you the property, they have their own insurance policy, which is a lot more money, almost 2 or 3 times what is normally made on the buy side. The seller's attorney will still collect that as their title agent. So they're making less money, but they're still making a lot of money. So, and which is why we'll get to that a little bit later, why in many cases the seller's attorneys fight back on this.
Faisal, that's what I was going to interject a question, but would it be better to save that until you get
Let's fire the questions. Let's make this interactive so people aren't.
Yeah, well, I mean, that's what I was going to say, is clearly it's not a zero-sum game, right? So if the client's saving money and the buyer's attorney is making more money, that's got to come out of somewhere, right? Is it fair to say that's coming out of the seller's attorney fee? Is that accurate?
So the seller's attorney is making less on the transaction.
They're making less. I mean, it has to be that way, right?
So they're still yes, they're making less, but they're still making a significant amount. They're making a good chunk of change on the transaction that justifies the whole deal. So
in the ones you guys have done, have you ended up making more on the buy side, or kind of, can you give an idea of what those numbers have looked like if you've done a bifurcated title? How much has the seller's attorney fee brought down, and how much has ours gone up?
So you figure that the seller's attorney's fee, all right, so on the buy side, the buyer's attorney is probably making an extra $500, maybe $700 more.
Okay.
Right. And the interestingly enough, the seller's attorney is making probably about $1,000 less.
And how have they reacted to that?
So in many cases they fought it, right?
Yeah.
But unfortunately, because the law says you can do it, there's not much they can say about it. And
Or
one of
the
the
deal won't go through, right? If they don't agree.
what's that?
I said if they don't agree with it, well, the deal can't go through, right?
Well, you can't cancel the. We're not going to cancel the deal and hurt the buyer, right? So the buyer's attorney is not going to do that because it's really first of all, it's the client's choice, right? So you explain the risk, but the seller can't cancel the deal on that basis. That's not an option for them to cancel the deal. So once the deal is closed, like once it's executed, really the seller has very few options to cancel the transaction. Most of the opportunity to cancel a deal comes from the buyer side, unless the seller can't for some reason close. You can't get the lender to accept a lower amount for a short sale, or there's not enough money to close and they can't come up with it on their own. But there's some sort of transactional issue, right? On the ability to close. But the seller does not have a readily available option to choose to cancel the deal.
And that was going to be my question. So I think you answered that, but just so I fully understand, I'm guessing you've probably had some threats of sellers' attorneys to try to blow up a deal, but they really wouldn't have a legal basis to do that, right? If this is the thing
Right.
you're fighting about.
Well, right. They can't for several reasons. One, because of the law that we talked about earlier.
Yeah.
Right. So based on this statute, the consumer has an absolute right to choose what title company they want to use. They can't force it on them. If they do so, they'd be violating the law.
Right.
Right? Now, obviously, they're not going to go to jail for it, but it also brings in some issues from a professional responsibility standpoint, right? So you're choosing to cancel a deal because you're not making enough money.
Yeah.
So what happens now, the seller's attorney will be putting their own self-interest ahead of the seller.
That's what I was going to say, because if I'm understanding it correctly, the seller probably doesn't give a shit, right? Their only concern is let's get the deal done. So it's the attorney, him or herself, that is impacted.
Absolutely.
Right?
It's the seller's attorney specifically, and only the seller's attorney who's impacted.
That is impacted. Okay.
Correct.
That makes sense.
Right. And now be very clear, right? So doing a bifurcation from the buyer side, the fact that the buyer's attorney is making a benefit is a subsequent basis, right? It's an after the fact type issue. The purpose of the bifurcation is to save the client the money at the closing. That's the whole purpose of the bifurcation, is so that the buyer is saving that money at closing.
It's just a happy side effect that the buyer's attorney gets to make.
It's a happy side effect, right?
Okay.
Exactly. So that's very critical in terms of the intent of the buyer's attorney, is to save the client money. So that needs to be expressly pointed out in your engagement letter, in your explanation, and as we'll get through towards the end and some of the questions. But when doing this transaction, right, it is very important. It is very, very important that the buyer's attorney explains this at the outset, right? And it's not done in an aggressive manner. It's more of a matter of fact, here's what we're choosing to do. How it's presented and the early part of presenting it is very critical. So there are attorneys out there that we know of who have sprung this almost literally at the 11th hour, like a week before closing or a couple of days before closing, which creates total havoc on the entire transaction. So the title company is expecting the fees, the attorney's planning for those fees, they've set everything up to do so, and now the whole transaction is flipped upside down because the buyer's attorney sandbagged the seller's side with this, I want to choose our own title company.
Is there any time frame when it should be? I mean, I'm thinking by what you're saying, I'm sorry to interrupt, that it should be presented in the attorney review letter, correct?
We would strongly recommend it presents the attorney review letter. However, there is a part where the title is issued. So, for example, the title commitment is sent out to the buyer's attorney later on in the transaction after attorney review.
Okay.
So that may show up maybe 5 days or 10 days before closing.
Right.
Within that title provision in the contract, I can reject the title or reject any part of it and say, nope, we're not going to do this. We're going to go with our own title company. We don't like what you're presenting. So, which means that's happened towards the back half of the deal as opposed to having it up front, which is where it becomes very problematic for many of the title companies. And it really upsets a lot of people and upsets the seller's attorney and just makes the whole deal far more combative than it needs to be.
But he's walking away with a lot of money. He or she is walking away with more money, essentially.
Who?
The seller's attorney. Because
Yeah,
collecting on the owner's policy as well as collecting a higher fee.
correct. They're collecting out more. They're collecting on the owner's policy. They're collecting on a higher lender's policy, and they're collecting on the endorsements, in addition to their regular attorney's fee. So when you bifurcate, they only get the owner's policy on the seller's side. They don't get the rest of the fees on the buyer's side. Any more questions? I guess that's a no. Okay.
Nope.
All right. So how do I bifurcate title? I hope you can read this. It's kind of small. I tried to make it a little bit bigger, but essentially through the life of the deal, right? So it starts out by executing the contract. So in some cases, in most, and I would say 99% of the time, it's the contract's executed and the issue of bifurcating title never comes up. Now, if the buyer asks for bifurcation as part of their offer at the upfront, that makes life so much easier. Now, there are organizations such as NACA, the National Association of, I can't remember what they stand for, but what they do is they provide low-income, affordable lending, and they've got a whole program in terms of helping borrowers and low-income borrowers and medium-income borrowers actually buying property using their program. So it's a whole program, but part of their program requires their buyers that they're going to lend the money to. They provide money like CRA funds, community reinvestment funds that banks have to give them. I'm not going to get too detailed on that, but part of their contract requires that they use their contract and requires NACA provides the title. So they'll do the entire title policy. They'll pay for it. So their seller's policy, the owner's policy, and the lender's policy and the endorsements all goes to NACA. And they obviously charge a lot less money. So that way the seller can't argue, wait a minute, no, I want to use my title company because now I'm not paying that title fee anymore. So if it was maybe a $2,000 title policy for the seller side, that just went to zero, and NACA says we'll take care of it. So it's almost like they seize the entire transaction. A lot of sellers' attorneys do not like NACA deals. So moving on, let us say that you don't have it in your contract and it's not a NACA deal. Then the buyer's attorney will make the request for bifurcation in the attorney review. Now, the seller's attorney may refuse this and require some increased, and this may require more conversation with the seller's attorney to explain it, because I'm pretty sure if I was a betting man, majority of sellers' attorneys have never done a bifurcation, right? Like I would say maybe 98% of them have never done a bifurcation. So it's quite unique. So they're going to push back a little bit. We've seen situations where the seller's title company will come back and say, oh, we'll match whatever fees you've got. And then he showed them the fees and they're like, oh, right? Because you're reducing it so much to benefit the buyer, they may not want to do it. And in some cases, they'll try to match it. And that becomes a question as to what we want to do going forward. Is it worth at that point now changing if they've reduced their fees so much? So it's a case-by-case basis.
Can I jump in here with a question, Faisal? Because this is what I written down earlier. It seems like the key to this is having a relationship with a title company and knowing that they're going to give you those low fees, right? I mean, is that fair to say?
Yes, that is thank you. Great question. Yeah. Great question.
You can't just be shopping this around. Like,
No. Yeah, not any title company can do this. Most title companies won't do it.
They won't do it.
But they'll push you away from it.
Right.
So you want to find the title company that's flexible enough and creative enough and innovative enough that'd be willing to say, yeah, no problem. We'll do bifurcations with you.
Like Inspire.
Like example, Inspired Title. They're a company that we use. We've used a few other title companies, but this was one that we've done bifurcation with. I've talked to other title companies who will do it, but again, they don't like doing it because it's not their bread and butter. They much prefer doing just a regular, I want to say just straight conservative, no frills transaction.
So you for sure want to have your relationship with the title company, make sure they're on board with it, make sure they're comfortable, and that you are comfortable knowing what they're going to charge, and that that you can represent that it's going to be substantially less.
Correct. Correct. Absolutely.
Yeah. I mean,
Absolutely.
I think we understand that internally, but I think it's good to emphasize that I wouldn't suggest doing a bifurcation and put it out there and then go shopping around to a title company or make sure that your title company is on board. You want to make sure you've had the conversation, I think, with whomever your title company is, and make sure they know how to do it and what they're going to charge. That would be my advice, and I think that's what you guys do.
That is correct.
How would you put this in a contract, though? Like, so how it says it's much easier if the buyer asks for the bifurcation as part of their contract. So, because is there anything in the contract that states anything about a bifurcated title? I don't think so, right?
No. So in the current contracts, they don't do that. What it would be is either an addendum or it would be put into the it would be an addendum, or there's lines and there's a paragraph where you can add additional language in the contract, and you'd be writing it in that the buyer would be choosing their own title company, and the title company will be bifurcated if the seller's attorney objects.
Okay.
Because the seller can pick their own title, and so the seller pays their title and the buyer pays their title. So that's where it happened in the contract.
Got it.
So the next move now is, now that everybody's worked it out in the attorney review is closed and the parties now agree, the next part is we're moving to the third part of the stage, which is the buyer's attorney orders the title and then the seller's attorney orders title. So they're both ordering title policies and title commitments on the transaction. So the seller, here's the interesting part. The seller's title policy is only ensuring the title for the buyer. That's it. So normally, if you look at the what?
Just say that one more time. I'm sorry.
So when normally there's a title commitment, the title commitment will have who the buyer is, right? The insured, and then the insured's lender, right? Because they're providing the lender's policy on the title commitment. Because the lender's policy is being handled by a different title company, the title commitment will only have the name of the buyer. It won't have the lender reference in the title commitment. So then the next thing that they'll do, and they may reference it anyways, but they're not going to get paid for that part of the policy. They're not going to issue that policy. And then the buyer's attorney title company, the buyer's title company, will then go ahead and order their own title and their own title commitment. And then that title commitment will go to the lender, your bank, so that way they can make sure that they've got clear title and they get what they need and they get their appropriate endorsements. Any questions on that so far?
No.
Just fire the questions out. So if you need me to slow down, just tell me to slow down. I tend to talk very quickly.
No, not at all. What I was thinking is that how impressed I was how you threw this together. It's cool.
Well, thank you. I will not take that as an insult that you do not expect me to have the capability to do this. I'm going to take it solely as a compliment.
Thank you.
Yeah, no problem.
Because you know what
intended.
I'm like, I did this. I was like, I had to put together a fucking PowerPoint presentation on the drop of a.
Let's be careful about language. So I don't know if we beeped that out, but okay.
Oh, I forgot we were recording.
Yes.
So, go ahead.
No problem. So buyer's title company is the escrow agent. Now here's where it gets funky, right? So, I almost cursed there. So the buyer's title company becomes the escrow agent. So they're going to handle the mortgage documents. They're going to handle all the transactions. They're going to handle all the commission statements. So everything gets sent to the buyer's title company. And then the seller's title company will send the invoice, their invoice for their policy and their fees with the attorney, the seller's attorney's fees and any other costs that they have. They'll send all that to the buyer's title company. Buyer's title company will collect all that. Then they'll schedule the closing. Right. So now that we're doing COVID-19 and we're in this realm where we're not doing in-person closings, obviously there's going to be the scheduling is a little bit more flexible, or at least in terms of where it's going to happen. but the closing is scheduled, and then everybody is sending all their documents to the buyer's title company to set it up. Then we close the deal. When at the closing, everybody signs, and then the buyer's title company will issue a check to the seller's attorney, the seller, and the seller's title company to pay for the title fees.
Huh.
And then they'll issue all the money for the buyer side, whoever needs to get paid and satisfied and taken care of on the buyer side. So that is how you bifurcate a real estate closing and why you would do so. Any questions?
No, it answered any of the doubts that I had about it.
So, Faisal, can you talk about specific objections you've had from sellers' attorneys and how you guys dealt with those and how you got folks to where you needed them to go, if you did?
Absolutely. And I would invite, if, I know that you can probably hear Monica and Margo, I would invite the two of them. If Monica's done a few of them, I know Margo's done all the bifurcations with me that I've done, which have been interesting. I also, one of the big ones, like I said, was where they were like, they couldn't, I know the first one, they couldn't figure out how to do it. Like, well, how do we do this? And how's this going to work? And so they were really objecting as to the process and the format and the scheduling. And they'll come up with a bunch of different reasons as to why they want to do it.
One thing that I've heard used in the way that they sell it to their client as to why they're trying so hard to avoid it, besides for them not getting paid as much, is that it complicates the deal and it increases the time that the seller has to wait for things. So basically adds to the timeline. That's one thing that I remember, because I haven't done one in a long time, but I remember that was one thing that was said. That it might drag the deal on, and then close as fast as it wanted to.
Is that a valid concern, or was that just because they didn't understand how it worked?
No, it is valid in a sense. It does complicate the deal. It does. And depending on the other title company, when everything's all in-house, it is easier. That's the thing. It does have its cons. It does have its cons. It makes us more money and it allows us to control pricing and stuff like that. But when everything's under one roof, things move a lot faster. Because now, when you think about it, even like when you make changes to the HUD and you send that to your title company, well, now your title company has to communicate with the other title company. So it's adding
I see.
have to communicate between the two of them now.
Well, just to clarify, I don't once the seller's title company, as we've done them, once the seller's title company sends their invoice over, they're done with the transaction. So all of the changes to the transaction or the settlement statement stays all within the buyer's side. So in terms of prolonging it, it may expend the timeline gets longer because the seller's attorney is fighting over it, and then you need the parties to coordinate. So it may add maybe a week or two to the transaction, depending on how efficient it's set up. So that comes back down to the buyer's attorney being ready to do this and having their their systems in place. So don't do this if you don't have a system in place or you're actually good at it. But yes, it does. The con is it can add more time, but it's not like it's going to add another 30 or 60 days to the transaction. We're talking about maybe an extra week or two, depending on if they're ready for it and how many you've done and how familiar you are with doing them.
And would you guys say that at the end of the day, these deals have closed very grudgingly, or has there been kind of a light bulb moment, or are sellers' attorneys ever going to be interested in doing this because there's no upside to them or their client? Is that kind of the bottom line? And they'll still just do it grudgingly because they have to, or if they're forced to?
So, I'd like to hear Margot's and Monica's perspective on that.
I'm going to join back in on this, but I'm going to join through my phone because I only have a small window where I have a car.
Gotcha.
So I'm going to disconnect and then I'm going to reconnect on my phone real quick.
Okay.
I mean, obviously Faisal and Margo can speak to this more than I can, because I think I was only around for like 2 bifurcations max, maybe 1. But yeah, I mean, there is no upside for a seller. So you basically have to convince a seller to make, like, seller by seller, I mean seller's attorney to make less money. But the thing is, they really don't have a choice. So yes, it does create, from when I saw it being done, yes, it did create tension over, anything and everything, because you're taking money out of their pocket, but realistically, you're putting it in your client's pocket, which is really why we're all attorneys in the first place. So I think it's like, I almost challenge sellers' attorneys to find an excuse that's not, this is taking money out of my own pocket. You know what I mean?
Yeah, and that seems to be the bottom line. So I think, and I don't want to oversimplify stuff, but kind of the point I'm trying to get out of this just for myself, and I think hopefully it'll be helpful for you guys, is what's the stuff we kind of just have to deal with? And it might be fair to say, look, sellers' attorneys are never going to be excited about this. It's just not a good deal for them specifically. But it's also fair to say that unless they're willing to commit ethical violations, and I'm not saying we have to phrase it that way, but I now have a better understanding of the seller's attorney really doesn't have the discretion to blow up a deal, or if they do, that's potentially malpractice or an ethical issue for them. I guess what I'm also trying to figure out then is, if we're never going to convince sellers' attorneys or have them on our side per se, who are the other people who have complicated these deals, and are there ways to potentially educate them or get them on board, whether it be an agent or whomever?
Yeah, absolutely. It's a great question, actually, Damon. Because in many cases, what happens is when there's a complication to a transaction, or there's some sort of complication, right? The seller's attorney will go, or the parties will try to go around the attorney and try to influence the attorney or influence the negotiation by backdooring the attorney.
Exactly.
So the key thing is getting first of all, the buyer on board immediately, right? So they have to understand what they're doing. They're going to get a benefit for this, and that they're interested in saving money. If they're not interested in saving the $1,000 or more, whatever it is that they're going to save, then at that point, so you're not doing it anyway, so you're good. Then the next two parties that you have to get on board, right? It's absolutely critical, is the buyer's agent, so the buyer's broker, the real estate broker, getting them on board so that they understand that the buyer is saving money and there's a benefit to them and this is working out for them and it's not going to blow up the deal. Now, they will also be resistant, right? Because they only get paid if it closes. So they don't want anything that's going to mess up the deal or complicate it or create an issue. So you really have to get the buyer's broker on board as well, that this is what's happening and that you're experienced, you know how to do it, and walk them through the transaction. And we've found that the best way to do that is you have some sort of flyer or a document that's very simple, one page, that explains how the transaction works. And then we present that to all the parties, including the seller side. So the seller side says, here's how it's going to work. Here's what's going to happen. You collect your fees. We collect our fees. You're okay. Explain it to the buyer's brokers and all the different brokers, so that way they're on board. If the broker is really vested in their client, which most are, but there are those that may not be. But if they are, they'll be like, hey, you can save my client $1,000 or $1,300 from coming to closing. That could make or break a deal, right? And some of these smaller deals that are FHA financing that are 3% down, $1,000 could mean they buy the house or they don't buy the house, right? So that's the part. That's the one. The last part that's really critical is the lender. And from the lenders I've spoken to, they love it, right? They love the fact that they can lower the fees, the closing cost fees for the client. And then here's the dirty little secret about that, right? So they may not all admit to this, they may not all do this, but if you lower the closing costs, right, there's still a closing cost credit that can sometimes come across from the seller side, okay? They'll get to raise their fees and use the closing cost credit to pay it.
Wait. Who gets to raise their fees?
The lender. The lender.
So it's an incentive for them too.
Or they get their fees paid for at the expense of the seller's attorney.
Got it. Okay.
So lenders love the fact that you can lower the closing costs, because a lot of times, and even if they're not benefiting from it financially, a lot of times their big struggle is the client or the borrower, the buyer, borrower, all the same thing, right? Client, having trouble raising enough money to pay and bring it to closing. So it's so the lender's usually on board, but your two big fighters are the seller's attorney, the seller's title company. That's two, and the third one I forgot to mention. The three big fighters. The third one is the buyer's broker, because they don't want to jeopardize deal or break the deal or hurt the deal anyway.
So Faisal, I think that's great explanation. What I would suggest as part of this presentation is maybe a slide or two breaking down those parties, because like I said, to me, that's a huge takeaway because I think you've got all the mechanics down. I think what would be really useful for us internally is to understand what the objections are, who's making them, what their incentives are, and how do we overcome them. Because that's just, I've learned a lot, honestly, just thinking through the mechanics now. Because like seller's attorneys in a bucket of, they're never going to want to do it, but we just know we have to deal with them. The buyer's broker, that's somebody who it kind of depends on their relationship with the buyer and their appetite for risk, et cetera. So I'm just kind of thinking of ways we can preempt some of that stuff and how to develop informational materials to deal with those risks. And I think understanding everybody's stake in the deal is really huge.
So I'm going to stop recording because I think we've stopped recording. So is there any more questions? Because I like that, Damon. I'm going to add that to the presentation.
Okay. Yeah, I was going to say that's not a question per se. That's the suggestion, I guess.
Yeah, no, thank you. I love the suggestion. It's a great idea. And I think this, I'm just testing this to figure out how this goes. We'll probably do another one of these in bifurcation so that way I can have it as this is 40 minutes and it's a little bit longer than I wanted it to go. But this is a good thing. So I'm going to stop recording right now. Any questions before I stop recording?
Nope.
No.
No,